Good morning. This is cause number 2822-20459 in the interest of Brooklyn and Brandon Dennings. All parties and witnesses, please raise your right hands to be sworn. You solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
All right, ma'am, please state your name and your relationship to the children.
Brandy Ruffin. I'm Brooklyn and Brandon mom.
All right, sir, your name and your relationship to the children.
Charles Dennings and father.
All right,
Possibly.
representing the father.
Yes, Your Honor. I represent Charles E. Dennings, the possible father.
And representing the Attorney General, State of Texas.
Morning, Your Honor. Kavita Sharma.
All right, what are we doing today, Ms. Sharma?
Yes, Judge. On August 3rd, the court held her testimony and granted a default order establishing the parent-child relationship with these children. And Ms. Taylor has filed a motion to set aside the default judgment in this case, Your Honor.
All right, Ms. Taylor.
Your Honor, my client has failed to file an answer, not due to unconscious indifference or mistake, but he had been told by Miss Brandy Ruffin not to answer anything because they were going to work something out and that she had dropped this Attorney General case. So she affirmatively told him that there was no case, and so he could ignore it. Then he found out he had a notice of a default judgment, and he hired me, Your Honor.
All right, Miss Ruffin.
That's not what happened. He asked me a while back to cancel. When I first did the child support in April, he asked me to cancel child support. And I was thinking about doing it. And I did call, and they said I couldn't cancel child support. My kids get Medicaid. So we were trying to come up with an agreement. He was only giving me $200 a month. And that was not enough for 2 kids.
Okay, Ms. Sharma.
Judge, the state would ask that you deny the motion because we do have an interest. These children should be supported, and Mr. Dennings does have an obligation to support the children with child support and medical support. In the order, Ms. Ruffin did not ask for any retro child support, and the state didn't ask for any retro medical or dental support. This is just for ongoing support. The children, from what I understand now, are 15 and 16, and Mr. Dennings has a responsibility and duties to support these children. We did give him notice to appear at the last hearing. He had every opportunity to do so via Zoom, which he did not. And I think the default order should stand. And Mr. Dennings' request for DNA, that would be up to the court's discretion to grant that or not. But at this point, the children are 15 and 16, and he had not brought these, the intention to have DNA testing prior to this date.
Ms. Taylor, you have a response?
Your Honor, I'd like to provide some information. I would like to take my client on testimony so that you might hear from him.
All right.
I call Charles Dennings Jr. What is your name?
Charles Edward Dennings Jr.
And you receive notice of that there was a child support case pending in this case?
Yes, ma'am.
And
Ms. Ruffin told me not to answer it and told me just give her some money and continue doing what I was doing. But she told me she was going to take care of it and don't answer the letters at all. So that's what I did. But if I
did not.
If I knew, evidently I would have went ahead and went through the whole motions of taking DNA.
Sir, he supposed to be
all the way through it.
Ma'am, nobody's talking to you, please. Go ahead.
so
Yes.
So what you're asking the court is to verify with a DNA test that these truly are your children. And if that's the case, then you are okay with what the judge has done.
Yes, sir. Yes, sir.
So that's all I have, Your Honor.
Well, how old are these children, Ms. Ruffin?
They 15 and 16, sir.
For 15 or 16 years, you thought you were the father, and now you don't think you're the father?
No, sir. It's just that when we was together, my oldest son, he's deceased. But the other two we wasn't really on good terms, but they just was up under my oldest son. So we friends. We're not together. We haven't been together in years, but I'm saying, like, if we coming up to a point like this, I would like to know, Your Honor, because we was together, but we wasn't just like we was this solid, like we was married or anything like that. We were just like fooling around.
Honor, can I say something, please?
Yes, ma'am.
If that was the case, he is lying, because when my son got shot, he was at the hospital. And when my son got shot, he stayed with him for a couple of days and he came back to my house. So he is lying if he think that was not the case.
Your Honor, we're not talking about the child who died. We're talking about
I'm
these other two children.
My Brandon Dennings got shot. That's who I'm referring to.
No, I'm saying that
He
the,
think that
the
was
whole,
here be
Wait
doing
a minute. Wait. Two people can't be talking at the same time here.
Yes, sir.
Ms. Taylor, do you have any questions, further questions of your client?
Mr. Dennings, at the time that these children were born or conceived, were you guys in an exclusive relationship?
6 weeks.
Okay. At this time, Judge, I pass the witness.
Can I say something, sir? He is lying. We was staying together in the house. We split up after Brooklyn got born. That's when he went to prison for a domestic violence case.
Okay, hold on just a minute. Okay. So if in fact he's the father, he will accept whatever the judgment is. Is that correct, Ms. Taylor?
Yes, Your Honor.
Let me just reset this matter and order DNA testing.
Thank you,
Okay.
Your Honor.
That's fine.
Case reset to November 2nd, 2022. Meanwhile, the order continues in effect.
We understand, Your Honor.
All right, thank you.
Thank you, Judge. May we be